Please be seated. We'll hear argument in 2309, City of Baytown against Schrock. Justice Lehrman cannot be present this morning, but expects to participate in the decision of the case.
May it please the court. Ms. Killian will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court. This is not a takings case, no matter how much Mr. Schrock tries to make it one. This case is part of a growing trend of cases where property owners try to frame their claims as takings claims in order to overcome governmental immunity in cases that do not involve direct restriction on property use. This is especially true for claimants like Mr. Schrock, who really just have negligence tort claims and cannot overcome their immunity, governmental immunity under the Tort Claims Act. This distinction between negligence and takings claims was clearly made by this court in the City of Houston versus Carlson case, where the court said a mistake is a claim of negligence and negligence is not a taking. Mr. Schrock's counsel explained in his opening statement at trial what this case is really about. He said, and I quote, "The City of Baytown made a mistake. The evidence is going to show they actually made several mistakes, and Mr. Schrock has been harmed by what happened." What happened was that Mr. Schrock did not like a utility bill, and instead of paying it and seeking a refund for what he believed he didn't owe, he abandoned his property and allowed it to waste away for nearly a decade. He wants the city to compensate him for the waste that he allowed to occur and his decision not to rent his property. That's not the way takings law works, and the Court of Appeals erred in holding that these facts could constitute a taking. To overcome immunity for his negligence claim, Mr. Schrock would have needed to allege and establish a valid waiver under the Texas Tort Claims Act, which would have required him to show that the city caused his damages by use of motor-driven equipment or a motor-driven vehicle. He hasn't made those allegations. Because municipalities' liability is so limited under the Tort Claims Act, claimants have an incentive to try to plead their claims as takings claims. Most of the time, courts can determine that the claim is not really a taking and dismiss it. But in this case, the Court of Appeals really lost sight of what takings law is about. There are two types of takings. There are physical takings and regulatory takings. Physical takings are easy to recognize because they involve some kind of physical occupation by a governmental entity or physical appropriation or possession of property. In those cases, compensation is categorically required. We don't have any appropriation of property here. We don't have physical occupation.
Does the placement of a lien, which which restricts potentially the ability to sell or transfer the property, does that constitute the type of conduct that could be considered a taking?
Thank you for that question. I don't think so. I think traditionally the physical taking is going to be a physical possession of property, physical occupation, some kind of like a flooding or some sewer lines, things like that are physically at the property. A lien is not a physical restriction. In this case, Mr. Schrock doesn't really challenge that anyway. He challenges he challenges the placement of the lien and he challenges the withholding of the services, but based on the city's mistakes, which makes it rooted in negligence. And
well, a zoning ordinance is not a physical restriction either, but that can be a taking.
Absolutely.
So could a city just rewrite its zoning ordinances to place liens and thereby say no, that there wouldn't be a taking in those cases?
I'm not sure, Your Honor. That's a good question. Here, there's just a zoning ordinance is a land use restriction.
Okay, but what if the city said, if you try to use this for any other purpose, a lien is automatically placed on your property and you can't dispose of it?
I think that would be going into whether that would be an unreasonable land use restriction, and you would go through the factors.
I thought you were saying a lien is not a land use restriction.
A lien is not a land use restriction in a physical sense, a physical taking.
Right.
Right. So if we're talking about a land use restriction,
taking?
I'm sorry.
Can it be a regulatory taking? I took it your position was it can never be a regulatory taking, and so I'm trying to understand if under some circumstances a city could use a lien to effect a regulatory taking, and if so, where that line is.
Okay. I don't have an answer for you on that right this time. I think your question is going to whether the ordinance itself is a land use restriction. And it isn't, the city's intent when it passed the land use, the ordinance in this case, wasn't to regulate land use. And so we are missing those elements of intent and public use. That there are the three elements of a taking in Texas, intentional act that causes a taking for public use. And those elements of intent and public use are inherent in a land use regulation like a zoning ordinance, because it shows that the city clearly intended to restrict the use of property. And in this case, what we have is a utilities ordinance that doesn't show any intent by the city to restrict his use of his property. He could still rent his property. He could still.
Wouldn't that turn a taking into an intentional tort claim, though? I mean, we said in the Rowlett case that in a regulatory taking, it's the passage of the ordinance that injures the property's value or usefulness. Isn't that all that's required to be shown?
Yes, you are correct. So what I was getting at is when it is a land use regulation, the intent and public use elements are clear because it's clear the city intended to restrict the use. But my point is that this is not a land use restriction because it was a utilities ordinance where the city was setting forth a process for collecting on outstanding utility bills. The overall intent behind it was to try to keep costs down for the public, which would, many outstanding bills like that over time is going to cause the cost of utility bills to go up. So the intent behind the city's ordinance was not to regulate the use of land, but to set forth a process for collecting those outstanding bills. And under Carlson, where the property owners in Carlson challenged the city's process for getting the repairs and the certificate of occupancy for the condominium, this court said that challenging a process or the procedures that a city puts in place is not a challenge of a land use restriction. It is.
But isn't he also challenging the underlying ordinance in this case, unlike in our Carlson case?
I don't think he was challenging the actual ordinance itself. He had a declaratory judgment claim where he wanted to ask the court to invalidate the ordinance. And again, it's not a land use restriction anyway. So even if he was challenging the ordinance itself wasn't intended to restrict the use of land. So if we open up the door to allow any kind of something that tangentially affects property use in some way, we could arguably be allowing takings claims in situations where a dump truck causes damage by slamming into the property, which we know it wouldn't be a taking, but it would affect the use of property. It would damage the property, but that in and of itself isn't enough.
But if a dump truck is parked to block all access to the property, even temporarily, that could be a taking, regardless of whether it was parked there intentionally, right?
I think that gets into the Tort Claims Act a little bit because you're talking about intentional acts, and the intentional acts are, the Tort Claims Act says that intentional torts are, the government is immune from intentional torts. So intentionally doing something, when you're looking at, or I guess it could be a physical
I was just picking up intent from your test. So I guess I understand the concern that we could sweep too broadly, but I'm also wanting to be sure that we don't write a rule that allows cities to circumvent the constitutional restriction on requiring compensation for takings by recasting what they're doing as a lien, and then requiring some sort of inquiry into intent that it's not clear to me how you determine intent. Okay.
I think the first thing that we should take from that is, again, the three elements of a taking are intent, an intentional act that causes a taking for public use. So when a city passes a zoning ordinance to restrict the use of property to only commercial use, it's clear that they are intending to interfere with the use of property and place a restriction there that only, the property can only be used for commercial use. When you have a utilities ordinance where the city was setting forth a process for collecting outstanding bills, that's not an intent to regulate the use of property or
Well,
access.
You said earlier that intent, it's the act that has to be intended. So what cases shed light on what the intentional, I mean, I assume the city intended to pass the ordinance and intended to place the lien. Are there any cases that shed light on what intent beyond that is required to have an intentional act for takings purposes?
There's certainly, I'm sure there are cases, Your Honor. I didn't bring them here today, but I can certainly present them to you later today if you need to.
You said that, that the remedy that Mr. Schrock had was to seek a refund. And I'm wondering, because your position is that the claims he would have brought for negligence are immune, well, how does he affect, how would he have affected remedy? Because the city, I think, concedes that the ordinance and the lien were improper. So how would he have affected that remedy?
Thank you for that question. Well, he did appeal the amount of the lien, and he went through that administrative process, and the city reduced the lien. And then he just, again, abandoned his property. He didn't do anything about it. The
But
remedy,
once he lost the appeal, or I partially won the appeal, but still had some utility bill to pay, did he have a further remedy that he could seek?
well, he could have sought an appeal from that decision through the city's administrative process, which he didn't do. He could have paid the bill and sought a refund at that point, which I think would have been a reasonable route to take. He admitted that he had the funds to pay it. It wasn't a very big bill. He tried to go pay it twice, but he decided he just didn't want to pay it and just wanted to abandon his property instead. I think that it sets a dangerous precedent to put all of that decision, whether something's a taking, this choice to abandon your property, and make expand takings law beyond what it is, and allow this causation element to be affected in that way. I mean, it certainly wasn't foreseeable that he would choose to boycott a bill and abandon his property for a decade because he was angry about it. And I think that goes, to another element that he's missing in his takings analysis, which is his causation element.
Does the precedent on unconstitutional exactions apply here?
It doesn't apply. An exaction is when it has to do with development of property. So when a property owner wants to develop property, they go seek a development permit from the city. The city, if it is an exaction, would say, well, we're conditioning the granting of the development permit on you granting some public access to the property or something like that. And the courts have said that it's a way of the property owner would have otherwise be entitled to the compensation for a taking, and it's usually a physical taking. But in giving up that compensation, they would be granting some kind of public access, the famous Nolan and Dolan cases where the property owners had to grant a walkway path for the public to walk through their property in exchange for a development permit. And so the court goes through an analysis there about whether or not they can do that, whether they can condition a development permit. But exaction cases are not, they don't apply outside of a development context, or they haven't. I have only a minute or so left on my time here, so I just want to touch on Carlson very briefly. So again, in Carlson, the building official for the city of Houston, he told the property owners of condominiums to repair their property and obtain a certificate of occupancy. The building property owners decided not to do that, and the building official ordered them to vacate. The property owners sued for a taking and argued that the order to vacate was a taking and that it was based on mistake that he issued the order to vacate. Here, Mr. Schrock is challenging the lien, he's challenging the withholding of services, and he's saying that those things were issued against him and withheld based on the city's mistakes in applying its own ordinance because it knew or should have known that he was renting the property, and mistakes in applying state law. And this court held that those things don't amount to a taking, that the process or procedure that was involved doesn't amount to a taking. You have to challenge a land use regulation. A land use regulation is, again, easy to spot as far as whether it's a taking or whether you engage in an analysis of a taking, because it clearly shows that the city or the governmental entity intended to regulate the use of property, and we just don't have that here. There's no clear intent. And at that point, I need to reserve the rest of my time.
Any other questions? Thank you, Ms. Killian.
Thank you.
We'll hear from the respondent.
May it please the court, Mr. Musamichi will present argument for the respondent.
May it please the court, my name is Rob Musamichi, and I'm here to represent the respondent, Mr. Alan Schrock. The Court of Appeals held that it was reversible error for the trial court to grant directed verdict against Mr. Schrock on his regulatory takings claim, and this court should affirm, because the evidence at the trial court raised a material fact issue on each element of a regulatory takings claim, and a material fact issue on each element of the, was raised on the material element of the Mayhew Penn Central balancing test. The standard of review is de novo, and the directed verdict should be sustained only if there was no evidence more than a scintilla on each of the vital facts. The Fifth Amendment and the Article 1st, Section 17 of the Texas Constitution point out that no person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. I love this case. I mean, Penn Central in 1978 pointed out the importance of the Fifth Amendment to private property rights, where they pointed out that the Fifth Amendment guarantee is designed to bar government from forcing some people alone to bear the public burdens which in fairness and injustice should be borne by the public as a whole. And with all due respect to my counsel on the other side of the aisle, what she pointed out was literally that the purpose of the city was to keep costs down due to the outstanding bills of some of the tenants that were not paying. And so they basically came up with a scheme to make some persons pay for all of those unpaid and uncollected water bills. So that actually is what was in the Pennsylvania Cole versus Mayhew case. I mean, think about owning a house, but finding out that you don't have rights to the surface of the dirt below your home. And so the Pennsylvania legislature decided that they were going to create a law that would allow the coal company to have the property rights below the earth of your home, and that property right, regardless of how much value it was, would be superior to the rights of the house, and so that they could extract the coal even though that your house might become falling into the pit.
So the counties and school districts and other government entities, they collect taxes. And when the taxes go unpaid or there's a dispute about the amount of payment, counties place liens on property. If it's ultimately determined that the county was incorrect in levying the tax or that the amount of the tax was incorrect, is that enforcement, does that constitute a regulatory taking?
Well, Your Honor, I don't know the answer to that, but let me explain why I think that what happened here in the city of Baytown is different. Because what they did was they introduced a regulation that didn't affect Mr. Schrock's actual liability. They enacted a regulation that created a scheme by which the debts of third parties would be Mr. Schrock's liability.
He, as the owner, was to guarantee payment of the utility bill by his tenants.
But that was,
and it was not in accord with state law. I understand. But if a county levied a tax that was not in accord with state law and did all the same things that the city did here, would that constitute a regulatory tax? I'm just trying to understand how any improper enforcement of an improper ordinance how that wouldn't turn into, I mean, it seems like under that theory, anything could be a taking.
Well, under the Penn Central factors, let me go down the Penn Central factors, which were still followed in this court's opinion in Mayhew. And because in the Penn Central, they found that it was kind of hard to find. It's an ad hoc analysis. But in following Pennsylvania, Cole, and Mahon, if the regulation goes too far, is the analysis. If the regulation goes too far, it's a taking. And so we found that if the economic impact of the regulation on the claimant is one of the factors, the extent to which the regulation has interfered with the direct investment-backed expectations of the claimant, and then the character of the government action. So in your analysis, or your hypothetical, the character of the government action really is valid. There is a legitimate interest in collecting taxes. So I would submit that in your hypothetical, it is a legitimate point for the government to collect taxes, ad valorem taxes, that have been unpaid. So it perhaps would not reach so far as to be unreasonable for a government or a county to assess a lien or to place a lien for a legitimate purpose of collecting an unpaid ad valorem tax.
Well, I think the question, though, is there are all kinds of reasons why a lien for utilities or for taxes or some other lien the government might impose could end up being invalid. And is it always the case that if the lien ends up being invalid, whether it's illegal or there's some other technical defect or whatever, that the consequences of the lien having been imposed are a taking?
But I think, Your Honor, the idea of the lien itself is important in this case, but we have to really come back to why, or to the analysis of the balancing test itself. Because there's, under the takings law and the jurisprudence, the first step in the analysis is whether there's a physical invasion of the property. For example, under the Loretto case, U.S. Supreme Court in 1982, the teleprompter, the cable companies literally allowed for the placement of communication devices on top of an apartment building against the owner's consent. So that's a physical invasion. That's a physical taking, clearly deemed per se to be a physical invasion and deemed to be a taking. The Lucas case in 1992, where they disallowed the use, so there's no economic use whatsoever. And then we move into where in Lingle in 2005 point out that if we don't have one of those two scenarios, then we follow the Penn Central standards, which is exactly what this court did in Mayhew with the additional, of course, and that was written by Justice Abbott, now Governor Abbott, on behalf of a unanimous court, which also included an additional component, the substantial advancement of a legitimate state interest test, which has been shied away from the Supreme Court in Lingle. But Lingle itself says we either use the absolute regulation, the regulatory action, is it deemed per se because it's a physical invasion? If not, is the regulation completely deprive the owner of all economic use? And if that doesn't fall into it, then we use Penn Central.
And looking at deprivation of economic use, does the placement of the lien deprive the owner of any economic use if the property was never offered for sale and there's no evidence that it impacted the value of the property?
So it could. But at this point, what happened is we're at the directed verdict stage of the trial court. And so the Court of Appeals was facing a directed verdict decision. And they followed this court's decision in Mayhew, which followed the analysis of Penn Central. And under those opinions and under those factors, the Court of Appeals correctly applied the law to the facts. The Court of Opinions, it literally goes A, B, C, and D. It follows the Penn Central standards exactly. They went through the analysis of the economic impact of the regulation on the property owner, which was to first compare the value taken from the property and compare to the value that remains, which incidentally, and ironically, I would point out that this court was one of the first courts to actually, I think, identify just jurisprudence of takings, because in 1885, In G.C. and S.F. Railroad versus Fuller, although it's not necessarily a direct takings case against a municipality or a government, this court pointed out that in context of Article 1, Section 17, the idea of protecting private property, when a railroad decided to build a railroad down St. Emmanuel Street in Houston, there was a private right of action based upon whether there was a diminution of value of whether that railroad hurt the property owner's value. And if the court found that if there was a diminution of value, the property owners had the right to receive damages. And in fact, the balancing test said that if the railroad in fact increased the value, they might not have any value at all. But
Is there a difference between the investment-backed, one of the parts of the Penn Central test is investment-backed, reasonable investment-backed expectations. Is there a difference in the lien here that was imposed versus tax liens, for example, in terms of what the owner's reasonable investment-backed expectations are, that's separate from whether the particular tax or the particular lien here were imposed improperly?
Absolutely. And here's why. And because see, Mr. Schrock bought this property in 1993 for the purpose of rental. And and the record is clear that, and the Court of Appeals found that it was his expectation and his specific investment goal to purchase 2 or more rental properties annually for the foreseeable period of time over the next 10 to 15 to 20 years. It was his expectation and his investment goal to then, at some point in time, retire by then selling them off. He was going to rent them every year. And the record reflects that he continued to buy. He had as many as 20 or 30 rental properties. So when he then had, at some point in time, for about 10 years, these tenants had delinquent water bills. He didn't know that. The record reflects clearly that he had every one of his tenants provide a lease when they went to the city to acquire water in the tenant's own name. The record reflects he had them provide the tenant sent the lease, and their water deposit was higher than it would have normally been for an owner-occupied request for service. The Court of Appeals then also found that, that was his primary expectation. His primary expectation was rental investment. So when Mr. Cuellar, in January of 2010, came in there to try and turn on his water service, and he was told that he would not be entitled to water because there had been a lien placed on the property some 6 months earlier in May of 2009. He had already contracted with Mr. Schrock for a leasehold lease. And at that point, when he could not obtain water service, that tenant vacated the property. At that specific point in time, that tenant left. And at that specific point in time, the regulation that had been imposed on this property, the regulation that the city of Baytown had on its books, actually had an economic impact on Mr. Schrock. Whether it's $1 or $1 million, I don't believe is a relevant factor. It had an economic impact because if Mr. Schrock had owned a $30 million office tower and had lost a tenant, and instead of losing $600 in rent, he had lost $600,000 in rent, we'd still be arguing the same legal position.
Why wouldn't we look at the economic impact as the amount of the lien? And then, if there are consequences to not paying it and letting the utilities be turned off for years, that's a different story. But this all could have been addressed by paying what the city said was due, $1,100 or $1,500, something like that. And isn't that the direct economic impact of what the city did, and then the rest is caused by the way Mr. Schrock decided to handle the situation?
Your Honor, I understand the appeal that the petitioner is trying to make to that argument, but I think that's a red herring because it wasn't just $1,500. What the record clearly reflects, though, is that when Mr. Schrock went to first pay the bill, it was approximately $1,500. And then it went up. It continued to go up, even though they told him that some of his tenant had paid down some of that amount. So imagine now for a moment that the lien, even though it should have been a finite amount, didn't change, even though there had been payment down on that amount. And then when he began to then make payment in full, the record clearly identifies, and the Court of Appeals found, that they told Mr. Schrock, okay, we now need to talk to you about your other 19 rental properties. So it's not just $1,500. It could have been as much as $30,000 of all these others, because now they were going to essentially extrapolate, and I don't want
Did
to use...
he administratively appeal the improper assessment? And I don't, the lien, how many months was the lien in place?
Almost 4 years, Judge,
4
Your
years,
Honor.
okay,
Excuse
so
me.
48 months. Okay, so did he, in the administrative process, seek a refund, seek removal of the lien, appeal the decision that he won in part but didn't win completely to the next stage of the administrative process? And why wouldn't the administrative process have provided a remedy for the improper application of this ordinance?
Your Honor, the record doesn't reflect anything about whether there was, in fact, an administrative process that would have been available to him. The record does not indicate that there indeed was some additional step he could have taken. I wish there were, but it's absent of those facts. It presumes that he could have done this. But I think the record does clearly indicate that there was bad faith on the part of the city. I do assert that. And I do believe that the character of the government action in this situation, where we have a city ordinance that is directly in conflict with state law, does go to the factors of the Penn Central standard. And the Court of Appeals found this. The Court of Appeals found material facts to support their decision. For example, the evidence was that the government illegitimately and in bad faith knew that the property itself was rental property. The Court of Appeals found in this record that the city knew this was rental property when they filed the lien. Mr. Schrock had even filed his declaration in satisfaction of the ordinance itself a month before the lien had even been filed. So,
is there any reason that Mr. Schrock couldn't have, by contract, through a lease with his tenants, have provided to maintain his investment-backed expectations by saying, holding on to a deposit, for example, to ensure that the bills did not remain unpaid? Couldn't he have just contracted to have the tenants pay him if it turned out that they didn't pay the city?
I don't know, Your Honor. The tenants are contracting with the city itself. It's a city utility. They're the ones that have to get the utility water in their own name. The record doesn't contain any information that I could use to answer your question. I do know that what the city has done in this situation, based upon this record, is that they were using this ordinance to clearly do what Penn Central and this court in Mayhew and have given direction on what is not right about unjust takings, which is the idea of putting the burden of the public's benefit on the backs of a few. Because what has happened here is that, as I pointed out and I was describing in Pennsylvania Cole versus Mayhew, is the benefit of the public to protect all of these homeowners from having their land and their homes fall into the earth from a sinkhole is to have the burden on the coal owners. It's the same thing, because what the city was doing is saying that if we can't collect from either mismanagement or misfortune the uncollected water bills, we're going to have a few individual property owners pay for all of those extra uncollected debts. They had an ordinance that allowed them to do that. The lien itself is what happened. They used the lien to prevent from any new tenant from being able to turn on water at the property. And by doing that, the factors of the factors of the economic impact on the regulation of the property owner is what we have here now. So the evidence, there was evidence of material fact on the elements of the individual Penn Central factors. The economic impact to Mr. Schrock occurred when he lost his tenant. The Court of Appeals went down the line and found that he had purchased this home for $21,000. He had put money into the home. He had lost rents. And there's not an issue of, I see my time is about up. May I briefly finish my thought, Your Honor?
Finish your thought.
The issue about, he didn't abandon this property for 10 years. He was in the middle of litigation. And the irony is that the city of Baytown didn't even remove their lien until a couple of years after the litigation had been filed. For these reasons, Your Honor, I ask that the Court of Appeals decision be affirmed.
Any other questions? Thank you, counsel. Killian, I believe you have 5 minutes.
Thank you, Your Honor. Just a few things I wanted to address that were brought up. The first is whether Penn Central should apply here at all, and the city's position is that it shouldn't because this isn't a challenge to a land use regulation. If it is a challenge to a land use regulation and Penn Central were to apply, the question that Penn Central raises is whether overall the public should bear the burden of the regulatory action that was in place over the private landowner. It's a balancing test. It's a fact-sensitive balancing test that is undertaken. The court looks at the 3 factors and balances those factors, but also they're really looking at the reasonableness of what happened. What happened in this case was that Mr. Schrock abandoned his property and decided not to pay the bill and allowed his property to waste away.
If we go back in time, so the city amended its ordinance to comply in 2011,
Yes, ma'am.
but didn't remove the lien until June of 2013. So what are we to make of the fact that the city brought itself into compliance but continued to pursue its lien, or continue to have its lien in place and for about 2 years?
Well, I think, Your Honor, the city, if it could go back, it might make some different decisions. And again, whether it made mistakes or not isn't really part of the analysis for a taking. As far as, Carlson speaks to this and says allegations of mistake are just allegations of negligence. Yes, if the city could go back in time, it might do things a little bit differently, but ultimately they did remove the lien. They realized they had made a mistake. He never had to pay that lien. He did request services in 2012. The city provided services to him, and then he called and asked the city to turn them back off, and then he just left his property vacant. We believe it's still vacant today. Another thing to touch on, as far as going back to Penn Central and the factors. So as far as the economic impact goes, again, he didn't present evidence of an economic impact from the lien. The lien caused a $1,500 approximate burden on him. He could have paid that amount, and in fact testified that he could have paid that amount, but he chose not to. Again, the city released the lien. Placing the lien is not unconstitutional. There's no dispute that he expected to use his property as rental property, but that goes to whether what he did was reasonable under the circumstances. It's certainly people, their property, they can use their property in a way that is reasonable with reasonable restrictions. And so the only reasonable expectation would have been for Mr. Schrock to use his property with the restrictions that were in place at the time. He doesn't have any reasonable expectation that he could use his property any way he wants to without restriction, and that goes to whether the land use regulation itself is a reasonable regulation. We don't have a land use regulation in this case, but if it were a land use regulation, that is the question, whether the land use regulation itself is an unreasonable interference. The only reasonable expectation here would have been that he would incur a $1,500 charge that he might believe was improperly assessed against him, but it certainly wasn't reasonable for him to abandon his property and require the city to pay for all of the waste that he alleges occurred there.
Do you have a reasonable expectation, though, that a lien wouldn't be imposed in violation of state law?
I think that, again, whether the city made a mistake in passing its ordinance or enforcing its ordinance, those are all issues of mistake and negligence. And so
But I guess what I'm saying is, it's not a situation of it was just a mistake applying this lien to him. This type of lien couldn't be applied to anybody under state law. The city didn't have the power to impose such a lien.
Yes.
And it seems like that's a different situation from maybe they imposed a tax on some individual who wasn't supposed to pay it, but it was a valid tax.
I understand, and I'm almost out of time, so I'd like to just finish, answer your question. So whether an ordinance is invalid itself is not going to affect the takings analysis. You still would have to show that the regulatory action physically caused a physical interference or a regulatory interference, and that regulatory interference was unreasonable enough and severe enough to cause the public to bear the burden of that regulatory action. And again, in this case, the regulatory action was not a land use regulation. It was a utilities provision that imposed a lien on the property, which wasn't unconstitutional, and it would only reasonably cause a $1,500 fee, and the decision to not pay that fee and allow the property to waste away and to decide not to rent it for a number of years is really, we shouldn't be having the public bear this burden of that decision. It would be an unreasonable expectation under Penn Central.
Any other questions? Thank you, Ms. Killian. Case is submitted, and the court will take another brief recess.
All rise.